Minstrel. I am Ngwesi Modukbe Nyim. Thank you very much for joining us in another episode of our series on hire purchase agreement. So today we'll be looking at the remedies that are available to the parties there to a hire purchase agreement, whether such party is the hirer or the party is the owner. The remedies that are available to them in the event that one of the parties breaches the terms he is supposed to have fulfilled towards the other under the agreement. Of course, every relationship at all normally develops problems. Problems arise here and there in human relations, and so in commercial transactions as well. Troubles, misunderstanding, breaches, areas or incidences of conflict arise, and where they do arise, there must be a remedy to the party who has suffered a breach or a damage in relation to the actions or the inaction of the other person. So that's what we are going to be looking at today. I will just simply pause here and enjoin you as always to be a member of our community if you have not yet become a member of our community. And for you to do that, you simply need to click on the subscription or the subscribe button there in order to subscribe to our channel as a way of supporting us and also having access to our videos as they drop and any other thing that is available for persons who are members of our community. Thank you so much. And if you like our videos, I will also encourage you to give us a thumb up and share with our loved ones. We also look forward to having your most valued feedback from the comment section. It gives us a traction in terms of moving forward with our production. Thank you so much. Today, like I said, we'll be looking at the remedies that are available to the parties under a hire purchase agreement. And we'll be looking first of all at the remedies that are available to an owner where the hirer is in breach of his terms under the contract. So there are essentially three remedies we'll be looking at. The first of these remedies is damages for failure to take reasonable care of the goods. Damages for failure to take reasonable care of the goods. Second, recovery of balance after payment of relevant proportion. And thirdly, right to repossess the goods. We'll begin by looking at damages for failure to take reasonable care of the goods. Which goods are the subject matter of the hire purchase contract? So where a hire purchase agreement has been determined by the hirer shall, if he has failed to take reasonable care of the goods, be liable to pay the the owner damages for the failure. And this, of course, is in pursuant to Section 8 sub 2 of the Hire Purchase Act. However, no liability will arise where the hired goods are destroyed, damaged, lost, or stolen in circumstances in which the conduct of the hirer in relation to the goods was not negligent. Again, if the hirer has terminated the agreement and wrongfully detained the goods, even after the owner demands for them, his conduct will amount to dirty, and thus he will be liable for damages. And you see this on the authority of Section 8 sub 3 of the Act, and also the case of Brady versus St. Margaret's Trust Limited. We now look at the second remedy that is available to the owner, and this remedy is recovery of balance after payment of relevant proportion. If the hirer defaults after he has paid the relevant proportion or deposit, the owner can recover the balance by court action. And you see this on the authority of Section 10 sub 1 of the Act. But pending the hearing, the owner can apply to court and he will apply to call for protection of his goods against damage or depreciation of those goods. And this is in pursuant to section 10 sub 3 of the Hire Purchase Act. Another remedy that is available to the owner is the remedy of repossessing the good, the right to repossess the goods. By section 9(5) of the Hire Purchase Act, the owner has the right to repossess the goods where the hirer defaults. So this right arises where A, the relevant proportion has been paid, B, there is at least a default of 3 installments of the hire purchase price, and C, an action by the owner is pending at the material time of the repossession. These 3 conditions are conjunctive, and once satisfied, the owner can conveniently repossess the goods from the hirer. The term relevant proportion of the hire purchase price of any goods is defined under section 9 sub 4 of the Hire Purchase Act to connote A, in the case of goods other than motor vehicles, 1/2, and B, in the case of motor vehicles, 3/5. So the Supreme Court has, however, relaxed this restricted right of repossession, and the Supreme Court did this in the case of Omoy Junafo versus Nigeria Technical Company Limited, the citation supplied on your screen. So for the sole reason of keeping the goods in a state of repair pending intervention by the court, the Supreme Court has endorsed the seizure or repossession of the goods by the owner even before institution of a court action, if at any time at least 3 or more installments are outstanding, notwithstanding that the relevant proportion has already been paid. So the right to repossess the good extends to third parties. Thus, where the hirer wrongfully sells the goods to a third party, the doctrine of nemo dat quod non habet applies, and that the doctrine of nemo dat quod non habet is to the effect that you cannot give what you do not have, and the owner can recover the goods from the third party because the goods were not properly given to him. The recipient of the goods from the hirer takes them subject to the iniquities in the hirer's title. So it is gratifying to know that an owner can even repossess in the following circumstances without any litigation. These circumstances include where 1. The right to terminate is rightly exercised by the hirer. 2. Where the relevant proportion is paid or tendered. And 3. Where the hirer voluntarily consents to return the goods. 4. Where goods are in possession of a person other than the hirer. 5. Where goods are abandoned or may reasonably be inferred to have been abandoned. So these 5 conditions so given, an owner can actually go to take over possession without any recourse to court action. And I will take them again. In a situation where the right to terminate has been rightly exercised by the hirer, the owner can take possession without recourse to court. Again, where less than the relevant proportion that the hirer ought to pay has been paid, the owner can also take possession, recover his possession without recourse to court. Again, where the hirer voluntarily, without duress, without pressure, consents to return the goods, then the owner can take repossession without any recourse to any court order. Then where the goods are in possession of another person, when they are supposed to be in the possession of the hirer, the goods now found themselves in the possession of another person other than the hirer, the owner can also take back possession without recourse to a court. And finally, where the goods have been abandoned, or they are in a circumstance where the owner can reasonably infer that they have been abandoned, then he can also take possession without recourse to court. With that, we will now move on to the remedies that are available to a hirer under a hire purchase agreement. These remedies are essentially two, and they are right to terminate the agreement and two, power of court to make a postponed order. We'll begin by right to terminate the agreement. Section 8(1) of the Hire Purchase Act permits the hirer to terminate the hire purchase agreement at any time. The law reserves to the hirer in appropriate cases the right, such as where the owner is in breach of a condition. We already said when we were taking on what condition means that a condition is such that the breach thereof renders the agreement as though the contract as though it was never performed. So upon termination, the combined effect of section 8(1) and 3(b) and c of the act is that any sum stipulated by way of minimum payment clause will be rendered void. So section 8(1) of the act limits the liability of the hirer in the event of terminating the agreement to the payment of such amount, if any, by which 1/2 of the hire purchase price exceeds the total of the sum paid in addition to the arrears of installments which have accrued before the termination. Section 3(b) goes further to make void the exclusion or restriction of the hirer's right to terminate to the imposition of any liability higher than the liability that is imposed upon him by the act by reason of the hirer's termination of such an agreement. We will now go to the second remedy that is available to the hirer, which is power of the court to make a postponed order. A postponed order affords the court the opportunity of giving a hirer who has defaulted in making payments after he has paid the relevant proportion a second chance to make good the default. So while the hirer is still in possession of the goods, the court may make a specific delivery order of the goods to the owner. However, the operation of this order, that is called a postponed order, is to expressly postpone on such new condition as the court may decide. I really hope that you get what that means. So I believe that you already know what to postpone something means. So a postponed order, what a postponed order does is that it enlarges the time within which the hirer can actually pay the owner back the monies that are due him. So that's what a postponed order does, and this gives him time to actually make good the payment he's supposed to pay, where he has paid a proportionate amount of money under the agreement. So with this, we have come to the end of the remedies that are available to the parties. We looked at the 3 remedies that are available to the owner, and we also looked at the 2 remedies that are available to the hirer. We said that the remedies available to an owner under a hire purchase agreement are: 1, the damages for failure to take reasonable care of the goods; recovery of balance after the payment of relevant proportion; and 3, right to repossess the goods. In relation to the hirer, we said the remedies that are available to him or her are: 1, the right to terminate the agreement; and 2, power of the court to make a postponed order. Thank you very much for being with us on this episode of uh, remedies that are available to parties under the hire purchase agreement. Thank you so much. We enjoy you to join our community by subscribing to our channel and giving us a thumbs up, sharing to persons you feel should also have it, and then finally kindly give us a feedback as it will give us traction on what we are supposed to do. See you in the comment section. Till next time, I am Nwese Modupe. Bye.